Ms. Cormier is charged with a first-degree felony offense of murder in clause number 25, DCCR 0153. Mr. Radford has filed this motion to quash the indictment. The state has filed a reply. Obviously, I've looked through both of these. I guess I'm confused, Mr. Radford, when you say it doesn't allege the requisite mens rea for murder.
Judge, if I may, common law has established that murder is when someone intentionally and knowingly causes the
Okay, but the statute is what we're doing.
Yes, ma'am.
Now pause.
Right.
The
I don't
defense
think it
attorney
was the
just
intention
invoked
of
1,000
the
years of common law tradition.
reckless
That's
correct.
like saying,
makes you
Your
think that?
Honor, history
Because
itself agrees
common
with
law
me.
going
But here's the twist. The Texas statute doesn't care about medieval England. It cares about modern fentanyl laws, which are among the strictest in the nation.
back 1,000 years requiring murder to be intentionally and knowingly.
But they've added section B4, which is a little confusing because the caption states it's 1902C, but the way it reads is the way B4 reads under 1902, which requires only knowingly, not intentional, knowingly manufactures or delivers a controlled substance included in penalty group 1B, blah, 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 fentanyl, that's what the allegation is. And so it actually has the mens rea of knowingly deliver. It reads straight from the statute. Someone would deny that motion.
Yeah.
Sure.
Just make more.
Yeah.
Under this indictment, under the way that it's worded, the doctor gives patients fentanyl, and the patient dies, and the doctor is charged with murder, even though he's not intentionally knowing.
Well, there's an exception. The next C, except as provided, well, which was it is a defense to the prosecution under section B4, which is our section that the actor's conduct in manufacturing or delivering was authorized under check 481 Health and Safety Code of State or Federal Law, which I think would be the medical purpose.
So,
So there's
this is my understanding and report of the opinion.
Notice
State
how
must
calm
prove
she sounds.
my
But
client
behind that calm tone
knowingly
is someone
delivered
accused of
fentanyl.
smuggling drugs inside a jail.
that's what the
That's
law
an
says, and that's
incredibly
what we cite.
high-stakes allegation, and one that could mean the difference between a reduced bond and staying behind bars until trial.
Is then and there knowingly deliver controlled substance, namely fentanyl, and that Shelby Urban died as a result of ingesting and inhaling fentanyl. So,
The opinion of the court that Ms. Cormier must have the reckless knowledge that she was committing a crime.
I think that's okay.
I'm
I'm not gonna. Well, I think that's going to be another whole question because it's specific that
It
it
says knowingly to
knowingly deliver a controlled substance, namely fentanyl. So I think that's going to come down to maybe a jury question. I'm not going to make that decision. That's not that's just an element of the offense. So the motion to quash.
statute is unconstitutional.
I'm not going to find
I
I'm going to follow it as written. Alright, so that's the night. Mr. Radford has also filed a motion to reduce the bond. Do you plan on calling your client, ma'am, the best you can? Raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may.
For the purposes of this hearing only, we'll call Michelle on here on the bond reduction.
Just so you know what she's under. I mean, I don't let anybody go far. She's under oath, and I am allowed to take into consideration some of underlying fact case. We won't go far, but just don't want you to think that we're not go there at all. Okay.
And you are clinically spaces, correct? Yeah. In your bond of currency, can you afford to talk to yourself? Do you have athletes in your name that you make family can help you? Have you talked to your family about possibly helping you? And how much what kind of bond you think the family can come up? 100,000. Would it assist your case and presentation of defense if you were bonded out? Assist me in working on it. Where were you born? And have you lived here? How long? So you pretty much lived here your whole life? Yes. Do you have family in this area? Yes. Where would you live if you were gone?
And there it is, the bombshell. The judge just summarized the entire case in one chilling sentence. Smuggling drugs into a jail, handing them to another inmate, and that inmate dies from fentanyl exposure. That's the kind of fact pattern prosecutors love. It's clear, emotional, and devastating.
Conditions of your bond, including GPS monitor and random drug testing, would you agree? What is your criminal history? See before? How much time did you spend?
After doing my call, and it's one and a half minutes. Yeah, that's it.
No, trying to I think it's probably in this report. What was Ms. Cormier in custody for when this happened? So the allegations here are that you were in custody for theft. In custody, smuggled in some drugs.
At this point,
of some
the
type
defense
in your
has made
vagina
its
that you
pitch,
gave to
community
someone
ties,
else, that
family
allegation
support,
has led to her
and
death.
willingness to wear a
That's correct.
GPS monitor. But judges weigh risk and danger more than sympathy. With fentanyl deaths at crisis levels, no one wants to be the judge who lowered a bond and saw tragedy follow.
Woman.
You don't want to see. Judge says, you in fact, low, gonna object these allegations are what he's trying to do now is by encouraging.
Thank you.
While you were in jail, you die, kill something. Again, judge, I'm going to object. That is not relevant. Move on.
Thank you.
Where did you object this job?
I think any of those are going to go through her Fifth Amendment rights and against self-incrimination.
Original down copy November 2024. PD felony drug case was has been written for 64 counts.
Status of that case.
I don't think it's been trial.
They're waiting on testing. Okay. Anything else?
No, ma'am.
All right, based on
3
the
defendants, 3
criteria under
outcomes,
17.15,
but the common thread,
the information that I
the
have, the nature
system
of the
balancing
offense,
law,
I'm going to
liability,
deny the
and morality.
petition or the request for
Whether it's a technical legal argument or a plea deal that seals a 50-year fate, this courtroom shows how justice isn't just about guilt, it's about interpretation.
I think 500,000 is adequate based on the nature of all of those matters. All right. Anything else then on this case?
No, ma'am.
Okay, we'll reset it for an announcement.
Matters.
Yes, thank you.
Due to the announcement, just kind of waiting on reports from my next term.
Okay, we'll just do a normal reset. Let's see what we write that for. Thank you. You can go back with the baby. All right, sir, you Howard Celeststeine? And Ms. Prazo, will your client waive the formal reading of the indictment in each case? Mr. Celeststeine, in cause number 24, DCCR 0919, you're charged with a third-degree felony offense of manufacturing or delivering a controlled substance from January 10th of 2024. That indictment alleges that you were previously convicted of aggravated sexual assault of a child, a first-degree felony, April 13th of 2009. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? And is that prior offense true? Prior conviction? The one that I read out, the aggravated sexual assault of a child, is that true, that is a prior conviction of yours? Clause number 24, DCCR 1549, says count 1 only, but then it says a 20-year term, so it has to be count 1 and 2.
That was mine.
If it's 20, count 1 and 2. Okay.
Oh.
There's only one crime.
Right.
So that's what makes that third degree turn into a
So it's second degree.
So pleading on count 1 would only be to the underlying offense.
Right.
Okay, so in 24 DCCR 1549, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from June 24th, 2024. The indictment alleges that same prior conviction from April 13th of 2009. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And again, is that prior conviction true? And did you enter your plea of guilty in this case freely and voluntarily? And because you actually did what they charged you with. So in clause number 24 DCCR 1550, you're charged with a first-degree felony offense of murder from June 24th of 2024, and the state's elected to proceed on that count only. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with. In clause number 24, DCCR 1551, you're charged in that case with state jail felony offense of abandoning or endangering a child from June 24th of 2024. How do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with. In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Carrazzo? Do you fully understand? And do you understand if I follow the agreements that you've reached with the district attorney, you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 at each. It's admitted in each case. Is there any evidence that Mr. Celeststeine has done?
No.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true in the cases that you did freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas in each case. In clause number 24 DCCR 0919, find sufficient evidence to find you guilty, and at this time find you guilty of manufacturing or delivering a controlled substance. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 20 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 1549, also find that you entered a plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 50 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to. In cause number 24, DCCR 1550, find sufficient evidence to find you guilty, and at this time find that you entered a plea of freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 50 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 1551, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will all run concurrently, which means together at the same time. I am making an affirmative finding of a deadly weapon in cause number 24, DCCR 1549. I'm handing you in all of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition,
but the common
about how long that lasts, you can talk to
the system balancing
Good luck
law,
to you, sir. You can go back with the
liability,
bailiff.
and morality. Whether it's a technical legal argument or a plea deal that seals a 50-year fate, this courtroom shows how justice isn't just about guilt, it's about interpretation.